Imagine this scenario. You've prepared for weeks. You've absolutely aced every single interview stage, sailed through all the tests, only for your dream job to be snatched away right at the very last minute. And not because of your skill or your qualifications. No, it's because a routine medical test reveals something deeply personal. That's a truly devastating situation, isn't it? Well, today we're taking a deep dive into Hoffmann v. South African Airways. It's a landmark 2000 constitutional court case from South Africa that confronted exactly this kind of discrimination head-on. Our mission, really, for this deep dive is to guide you. Maybe you're a legal eagle in training, or perhaps you're just really curious about how our rights get protected through all the twists and turns of this pivotal case. We'll unpack the powerful arguments, look at the court's reasoning, and ultimately explore its lasting impact on human dignity in the workplace.
Yeah, and what's truly, I think, groundbreaking here is how this case pushed South Africa's highest court to fundamentally redefine human dignity, especially in the context of this new democracy. It essentially established a really clear precedent. Your medical status can't just automatically block you from earning a living. It shattered these old prejudices that really had no place in a constitutional society.
Okay, right. So let's unpack the story then.
Yeah.
Our central figure is Jacques-Charles Hoffmann. Now, in September 1996, Mr. Hoffmann applied to be a cabin attendant for South African Airways, SAA. He went through what sounds like a pretty rigorous four-stage selection process.
Yeah.
Pre-screening, psychometric tests, a formal interview, and then a final role-play exercise. He passed them all. Deemed suitable for employment, along with 11 others. Sounds like he was, well on his way to that dream job.
Pretty much, yeah. Seems like smooth sailing at that point.
But there was one final hurdle.
Yeah.
A pre-employment medical examination. And this included a mandatory blood test for HIV/AIDS. Mr. Hoffmann was found clinically fit in every other way, but his blood test came back HIV positive. And as a direct, immediate result, his medical report was changed from suitable to unsuitable, and his employment offer withdrawn. SAA's position was, totally unequivocal. His HIV-positive status was the sole reason he wouldn't be hired.
So the immediate question then is, what possible justification did SAA even offer for such a blanket exclusion like that? Their rationale, as they presented it, was based on safety, medical, and operational grounds. They argued that cabin crew need to be fit for worldwide duty, flying to places like yellow fever endemic countries, which requires vaccination. And they claimed HIV-positive persons might react negatively to the yellow fever vaccine, risking maybe contracting it or transmitting it. That was the claim.
Got it.
SAA also brought up the risk of opportunistic diseases for HIV-positive individuals, which they believed could impair performance in emergencies. They even mentioned short life expectancy as a reason not to invest training costs.
Right, the cost argument.
Yeah, and they also pointed to similar practices by other major international airlines, sort of trying to bolster their position.
Okay, so on the surface, SAA presented what sounded like a solid, if pretty strict, rationale. From a purely business point of view, you might even argue it seems pragmatic, given the perceived risks back then. But were these pragmatic choices actually based on reality? Or maybe something else entirely?
And this is exactly where the narrative takes a really pivotal turn. You see, SAA's own medical expert, Professor Barry David Shobe, he actually contradicted their broad claims in an affidavit he submitted to the High Court.
Wait, their own expert?
Their own expert. Professor Shobe stated that only people whose HIV infection had progressed to the immunosuppression stage, which is indicated by a very low CD4 plus count, the measure of immune system strength, only those individuals were prone to the medical, safety, and operational hazards SAA was worried about. And crucially, he noted there was, quote, nothing to indicate that the infection has reached either the asymptomatic immunosuppressed state or the AIDS stage, for Mr. Hoffmann specifically.
So basically, SAA's big reasons didn't even apply to Mr. Hoffmann.
Exactly. They weren't true for all HIV-positive people, and certainly not for Mr. Hoffmann, who was still in that asymptomatic phase and otherwise healthy.
So SAA's own expert witness essentially pulled the rug out from under their main argument. It's quite astonishing. Yet, unbelievably, the High Court still sided with SAA. They claimed SAA's practice was, quote, based on considerations of medical, safety, and operational grounds, and, quote, aimed at achieving a worthy and important societal goal. The High Court even reasoned that if SAA were forced to employ HIV-positive individuals, it would be seriously disadvantaged as against its competitors. They actually concluded that being HIV negative was an inherent requirement for a cabin attendant job. But how could they just ignore their own expert's testimony like that? That seems odd.
It really does, doesn't it? And that decision from the High Court, I think, really highlights the prevailing fear and misunderstanding around HIV and AIDS at the time. It was quite pervasive. Despite the expert evidence, the High Court seemed to prioritize these perceived commercial interests and, frankly, outdated assumptions.
Right.
And this is precisely why the appeal to the Constitutional Court became so necessary. Now here, powerful medical evidence was introduced by the amicus curiae, that's a friend of the court, which was the AIDS Law Project in this case. And this evidence, it painted a much clearer, medically accurate picture of HIV. And it was drawn from a unanimous view of top medical experts, including, remember, SAA's own Professor Schob.
Okay, so what did this new evidence show?
Right, so first, on progression. They detailed the 4 stages of HIV infection, from acute right through to AIDS. They emphasized that in the asymptomatic immunocompetent stage, which is where Mr. Hoffmann was, the immune system isn't materially affected.
Okay.
Second, on transmission. It was stated unequivocally, HIV is transmitted only through intimate contact involving the exchange of bodily fluids, things like sexual contact or blood, never through intact skin or just casual contact. It's actually, quote, not a highly transmissible infection.
Right, dispelling a lot of myths there.
Exactly. And perhaps most crucially for the employment question, on treatment and employability. The medical experts confirmed that with highly active antiretroviral therapy, HAART, that's the combination drug therapy that suppresses the virus, individuals are capable of living normal lives and they can perform any employment tasks for which they are otherwise qualified.
Huge.
Absolutely huge. They also stated that any hazards to immunocompetent employees could be managed, risks to passengers were inconsequential, and critically, there was no well-founded medical support for a policy that all persons who are HIV positive are unable to be vaccinated for yellow fever. The ability to get vaccines, they said, should just be assessed individually based on their CD4 count.
Wow. Okay, that unified medical opinion must have completely changed the game. So SAA, faced with these hard facts, they just conceded.
They pretty much had to. They admitted their practice of refusing employment to all HIV-positive cabin attendants cannot be justified on medical grounds. And they admitted their refusal to employ Mr. Hoffmann specifically was unfair.
That's a massive shift from their original stance. So, with SAA conceding, what did the Constitutional Court do then? Couldn't they just say, okay, case closed?
Well, yes, it was a huge admission, a stark revelation, really, that these fear-based policies, no matter how entrenched they seem, they just crumble when faced with scientific truth and, importantly, human rights principles. But despite SAA's concession, the Constitutional Court's job wasn't just about this one employment dispute. It was their duty, really, to determine if Mr. Hoffmann's constitutional rights had been violated. They needed to set a clear legal precedent for the new democratic South Africa.
Ah, okay, so it was bigger than just Hoffman's job.
Exactly. They deliberately chose not to rule on SAA's newly proposed policy of testing for suitability. They emphasized that kind of thing fell under the specialist labor court's jurisdiction, especially because the Employment Equity Act had recently come into force and governed testing. Their focus was squarely on the equality clause that's Section 9 of the South African Constitution.
And the court established that SAA, because it was a business unit of Transnet, is an organ of state, right?
Mm-hmm.
Which means it's bound by the Bill of Rights.
Precisely. And that means SAA is expressly prohibited from unfair discrimination.
So what was the court's process for actually assessing whether discrimination had occurred in this case? How did they break it down?
Well, the court uses an established approach for Section 9 discrimination cases. It involves asking 3 main questions. First, is there a differentiation between people or groups that has a rational connection to a legitimate government purpose?
Okay.
If yes, then second, does that differentiation amount to unfair discrimination? And then third, if it is unfair discrimination, can it be justified under the limitations clause, which is Section 36 of the Constitution?
Right, the justification stage.
Exactly. Now, in this specific case, the court found it wasn't even necessary to delve into that first question about rationality. The discrimination was just so patently unfair on its face, they moved straight to its impact. Their focus was squarely on the impact on the person discriminated against, emphasizing that the Constitution demands equal dignity for all human beings, regardless of their, position in society or their medical status.
And it wasn't just about Mr. Hoffmann as an individual, was it? It sounds like the court took a much wider view looking at the whole societal context of HIV.
Absolutely. And this is where the judgment becomes incredibly powerful, I think. The court took this profound deep dive into the societal context of HIV in South Africa at that time. They highlighted that people living with HIV are a minority group, often subjected to intense prejudice, systemic disadvantage, and discrimination. They are stigmatized and marginalized, and frequently denied employment without regard to their ability. They explicitly called them one of the most vulnerable groups in our society. The court firmly stated that any discrimination against them is a fresh instance of stigmatization and a direct assault on their dignity. And it's especially devastating when it comes to employment because it denies them the right to earn a living. That's precisely why, the court reasoned, they enjoy special protection under South African law.
So the court wasn't just looking at the cold facts of this one case. They were considering the broader, kind of chilling impact of a policy like SAA's. They reiterated that SAA's blanket exclusion was based on, well, assumptions that are true only for an identifiable group of people who are living with HIV, not for asymptomatic individuals like Mr. Hoffmann.
Yes.
And they pointed out that glaring inconsistency, too. SAA didn't test its existing cabin attendants for HIV/AIDS. They were allowed to continue working regardless of their status, even though they might pose the very same health, safety, and operational hazards that SAA was claiming new applicants like Hoffmann posed.
That inconsistency was definitely a key point. It really undermined SAA's whole rationale.
It just seems illogical. And thinking back to the High Court seemingly overlooking its own experts' testimony earlier, what does that tell us about the societal climate around HIV back then in South Africa?
Oh, it speaks volumes. It really does. It shows just how pervasive the fear and the ignorance still were, even within institutions, even in judicial spaces, despite the growing medical knowledge. It really underscores why the Constitutional Court's intervention was so absolutely vital. This case brought up a critical question. Can commercial interests ever justify this kind of discrimination?
And the answer was?
A decisive no. The court warned against allowing stereotyping and prejudice to creep in under the guise of commercial interests. And what's really compelling here is their passionate statement that fear and ignorance can never justify the denial to all people who are HIV positive of the fundamental right to be judged on their merits.
Powerful words.
Very. The court emphasized that how we treat people with HIV must be based on reasoned and medically sound judgments, and that society must actively combat erroneous but nevertheless prevalent perceptions about HIV. They even invoked the profound South African concept of Ubuntu, that idea of interconnectedness, that my humanity is tied up in yours.
Respect for human worth.
Exactly. And applying that, they emphasized that people with HIV must not be condemned to economic death.
And perhaps the most powerful statement, really reflecting South Africa's journey out of apartheid, was, prejudice can never justify unfair discrimination. That was the court's emphatic final word on it, wasn't it?
Absolutely. That line resonates so strongly. In its concluding remarks, the court explicitly rooted this principle in South Africa's recent past of institutionalized prejudice under apartheid. It asserted that the new constitutional democracy demands respect for human dignity for all human beings. SAA, as an organ of state, couldn't just sidestep its constitutional duty by bowing to prejudice and stereotyping.
So just to summarize the finding on discrimination.
Right. To reiterate, the court found that denying employment to Mr. Hoffmann solely because he was living with HIV fundamentally impaired his dignity. It constituted unfair discrimination, violating his right to equality under Section 9 of the Constitution. And that third stage of the test, the justification under Section 36, it didn't even apply here because SAA's policy was an employment practice, not a law of general application that might potentially be justified for broader societal reasons.
Okay, so a landmark ruling is in, unfair discrimination established. What did the Constitutional Court actually do to right this wrong for Mr. Hoffmann? What was the remedy?
Well, the Constitution allows the court to grant appropriate relief, which has to be fair and just in the circumstances of the specific case. The court determined that the most appropriate relief for Mr. Hoffmann was instatement, which means exactly what it sounds like. SAA was ordered to employ him as a cabin attendant.
Instatement, okay.
And this decision, it was rooted in a fundamental legal principle. Where a wrong has been committed, the person who was wrong should, as far as possible, be put back in the position they would have been in if the wrong hadn't happened. Instatement, in this kind of context, it effectively strikes at the source of unfair discrimination. It sends a really clear message that discrimination won't be tolerated.
Right.
It also aligns with South Africa's international obligations on promoting equality in employment, and maybe most importantly, It restores the human dignity of the person who suffered the discrimination.
Did the court consider Mr. Hoffman's current health at the time of the judgment?
Yes, they specifically addressed it. They noted that at the time of the Constitutional Court hearing, he was asymptomatic, he was on combination therapy, HART, and he was able to be vaccinated against yellow fever. So, confirming his current suitability for the job. They also pushed back against the floodgates argument. The idea that this ruling would open the door to countless other similar lawsuits.
Ah, yes, the classic argument.
Exactly. The court basically said, look, the relief in any other potential case would depend entirely on the specific facts of that case. They weren't setting a blanket rule for all future scenarios.
Now, I remember reading Mr. Hoffmann actually sought instatement going back to the date of the original high court judgment, which had gone against him. But the Constitutional Court denied that specific backdating request. Why was that, if the goal was to put him back in the position he should have been in?
Yeah, that's a really good question, and it actually speaks to the court's focus on fairness to both parties involved. They denied the backdating because he hadn't formally requested it in his appeal papers to the Constitutional Court.
Ah, a procedural point.
Essentially, yes. It meant SAA hadn't had the opportunity to prepare arguments addressing the pretty complex financial and legal questions that backdating would raise, things like back pay, pension contributions, benefits, and so on. The court emphasized that those kinds of issues would need to be properly argued before they could potentially be ordered. So fairness dictated not granting it in this instance.
Makes sense. So the final order was?
The final order was for SAA to forthwith offer to employ Mr. Jacques-Charles Hoffmann as a cabin attendant. He was given 30 days to accept that offer, otherwise the order would lapse. SAA was also ordered to pay Mr. Hoffmann's legal costs for both the High Court and the Constitutional Court battles. And the court added a rather pointed comment that the litigation was unnecessary and had resulted from SAA's true policy having been applied incorrectly in the first place.
Ouch. A final word from the court there. So, bringing this all together, what does this case, Hoffmann v. South African Airways, mean for you listening today and for broader society? It feels like it's much more than just a legal case from, over 2 decades ago now. It seems like a powerful testament to that enduring fight for human dignity and equality.
It really is.
It highlights how medical advancements, strong legal frameworks, and importantly, evolving societal values have to converge to combat prejudice and ensure that people are judged on their actual merits, not on, unfounded fears.
Absolutely. And stepping back to see the bigger picture, the broader significance here is huge. This case was a truly crucial step in cementing constitutional protection against discrimination based on HIV status in South Africa. It underscored that prejudice, no matter where it comes from, whether it's fear, ignorance, or maybe perceived commercial interests, it has absolutely no place in a constitutional democracy that's built on the foundations of human dignity and equality for all.
And it really leaves us with a provocative thought to maybe mull over, doesn't it? In what other areas of life today, perhaps beyond employment, might lingering prejudices, maybe disguised as practical considerations or concerns about public perception, still prevent individuals from being judged purely on their true capabilities?
Mm-hmm.
And what role do each of us actually play in upholding those foundational values of equality and dignity, not just, through big legal battles like this one, but in our everyday interactions and assumptions?